Kelly Longtin from Kelly Longtin Law, and today I want to talk to all of you about the spousal lifetime access and what you should actually know about it. So none of us wants to pay more in taxes than we actually have to. So to carry out this objective, many people search for the perfect estate planning tool that will allow them to control as much of their money and property as possible while reducing the amount they or their loved ones will have to pay to the government. If you've looked for the tax-saving estate planning tools, chances are you might have come across what's called the Spousal Lifetime Access Trust, or for short, a SLAT. But I want to talk to you about some important things that you should know before you settle on this tool as your estate planning option. A SLAT is a type of irrevocable trust created by one spouse, so we'll call them the trust maker spouse, for the benefit of the other spouse. So we'll just call this person the beneficiary spouse. And it is used to transfer money and property out of the trust maker spouse's estate. Now, this strategy allows married couples to take advantage of their lifetime gift and estate tax exclusion amounts by having the trust maker spouse make sizable permanent gifts to this trust that will then decrease the value of their estate while maintaining some limited access to the money and the property that is gifted to that trust for the beneficiary spouse's benefit. The trust maker spouse gives money or property of which they're the sole owner to the SLAT for the benefit of that beneficiary spouse. And if the couple resides in community property states such as California, they will likely need to convert community property into separate property through what is called a petition agreement. The trust maker spouse reports the gift on a gift tax return. Then the beneficiary spouse can receive distributions from the trust from which the trust maker spouse may also indirectly benefit. Upon the death of the beneficiary spouse, the trust assets are transferred to the remaining trust beneficiaries, usually children or grandchildren of the couple, either outright or in trust. SLATs offer several advantages to those looking to minimize the value of their estate. First, not only is the value of the property that is gifted to the SLAT removed from the trust maker spouse's estate, but all future appreciation is also removed. The trust property is also excluded from the beneficiary spouse's estate, even though the beneficiary spouse may receive distributions from the SLAT. Now, SLATs are typically structured as grantor trusts, meaning that all of the trust's taxable income is taxed to the trust maker spouse, further reducing the trust maker spouse's estate. Plus, no separate tax return will be required for the SLAT while the trust maker spouse is actually living. However, if the SLAT is not structured as a grantor trust, a separate trust tax return would be required. Now, SLATs provide a way to have your cake and eat it too. And while spouses may be concerned about losing control over money and property that is gifted away, and whether that property will be needed in the future, a SLAT can address this uncertainty by allowing the trust maker spouse indirect access to the property through that beneficiary spouse. There are some drawbacks for using a SLAT. First, the gifts made to a SLAT are final and cannot be undone. Second is if the beneficiary spouse dies before the trust maker spouse, the trust maker spouse loses all access to the money and the property that was gifted to the SLAT. This would also be the case if the couple were to divorce. Now, the trust maker could potentially regain indirect access to the trust assets by actually remarrying. Now, the property gifted to a SLAT will not receive a step-up in basis at the death of the trust maker spouse. This drawback could be minimized by including a trust provision that allows the trust maker spouse to swap trust property, thus allowing that trust maker spouse the ability to substitute low basis property with high basis property or cash or equal value. Now, spouses looking to create SLATs for each other to utilize each spouse's exemption amount fully will need to ensure that they do not run afoul of what's called the reciprocal trust doctrine. Now, if the IRS interprets the two trusts as being substantially similar, it can undo the trust and include the trust property in the spouse's taxable estates, thus defeating the purpose of creating the SLAT in the beginning. Now, this drawback can be avoided simply by creating the SLATs at different times, using different trustees, choosing different beneficiaries, or providing for different terms for those distributions. So given the complexity and the tax implications, it is highly recommended that you consult an experienced estate planning attorney. In 2022, the gift and estate tax exemption amount is $12.06 million for individuals and over $24 million for married couples. It's a historically high amount. However, under current law, this amount is slated to shrink back down to $5 million plus the adjusted the amount for inflation on January 1st in 2026. This decrease in the exemption could happen even sooner if Congress acts to actually change it. So last year, the House Ways and Means Committee proposed cutting the gift and estate tax exemption in half, effective January 1st of 2022. But because the law could change at any time, the window of opportunity to take advantage of this estate planning technique is pretty narrow. Now, married couples who are considering taking such a step should really contact an experienced estate planning expert as soon as possible, so they can talk you through the pros and cons of using a SLAT and whether that technique makes sense for your situation. So I want to thank you all for watching. Just a little information, quick overview of how spousal access trust works, or as we call them, SLATs. So if you want to learn more about estate planning, please like and subscribe on our YouTube video and follow us so you can get notified of any new videos that come out to help all of you better understand estate planning. Thank you. I'm Attorney Kelly Longtin from Kelly Longtin Law.